Nanwada ena Chairman Wontumi ye man 20 years jail sentence. Aside 20 years nso eye fine ahodo a na eka ho ene ehon krone ba. After say sa jail sentence yi beto abonten de. Kana fo bebre na develop interest e wo sa asem ni mu a obi e kire na adwen on eye asem na bi mu kire se eye ohwe 20 years ye de ma Chairman Wontumi na ohwe asem ni mu duro any evidence ahodo a you provide ye against Chairman Wontumi a dodo na na e kase Chairman Wontumi deserve 20 years a ye de ma no ebi mumpo ego as far as omo che se sa 20 years yi anase jail mpo a ye de ama ye Chairman Wontumi ni nyina no ye politically motivated amanfo bi nso dwene se o hwe the level of degradation, land degradation any water pollution at Chairman Wontumi akose oman Ghana ne dia o deserve yes 20 years na ye de ne man na sa issue o deserve politically motivated politically motivated akoso from last week after say sentence ne beto abontia ba dia ba bedure ne ya Ghana for dodo na anu egusu ka ho asem a enya asem ketua na finally amanfo bi omo NPP amanyokuo ni mu omunim de ekọ ene de ba ebi ababonten ababe react to sansem we a ekoso ewo monten na sisi ade Chairman Wontumi lawyers a wode omukopie mu court a omadi asem na chi for so long so many months ebi ababonten ababe set record ni straight enya asem ketua. Now before that ni nyina enim say Chairman Wontumi wa ambition say NPP amanyuku no Ashanti regional chairman no obesa nso adisubium for another 4 years na eno de enioma hodo aka obetimi aye ede ama NPP amanyuku no watimi abone homoden aye de aboa NPP amanyuku nse de be ya omobetimi a capture and answer a winning political power in 2028 na amanfo bi kire mu a because of that inti na NDC amanyuku nanim the powers of Chairman Wontumi ni o ma hodo obetimi ayade aboa NPP amanyuku na ma o ma wi ni political power no eninti enene die omode no akwakopie mu ewo nsawam na say ye nokre ana asesa asemwe enye nokre bebo awram na yakwakotie Chairman Wontumi lawyers after case no explanations are omonso ede ababeto abonten ene ni o ma hodo a e course behind doors nyina no omide ni nyina ho asem aba jebusia.
I still stand by that, and that is the fact also. He told me that he had prior information that he will be convicted, and therefore gave me instructions first after the conviction.
I see.
And this is a fact.
He had prior information that he was going to be convicted on Monday.
And again, I am going to show you why probably he had that prior information. This is a copy of the judgment. Look at it. Judgment didn't go to even the registry of the court. So there is nothing to show that there is. This is on a regular A4 sheet. The courts have their own sheets that they use in publishing judgments. So there is no indication of the stamp of the registry. You go down there at the end of it, and it says that counsel, and in this particular case, defense, attaching for the first and third accused persons. Attaching was not in court on the day. So it would have been that Mr. Appiah could be holding the brief of somebody attaching.
But you were not in court on that day.
No, I'm saying
you're just taking an example.
Somebody else,
but even before we get in
somebody else held the brief on the day.
Right.
So ordinarily,
the person's name
will come, and then you refer to the lead counsel or the senior whose brief the person was holding.
Now,
so this is a publication that came even before the judgment.
Did you ask that's Chairman Wontumi
No.
further on Monday why he suspected that he was going to be convicted on that day, even before he went to court in the morning?
And I'm saying that he probably had a copy of this before the judgment.
He had a copy of the
judgment before it was delivered. Read. And I'm justifying that with these observations. But the most important thing I want to set today is that people who have not had the opportunity of reading the proceedings, people who have not had the opportunity of even reading the address and going about relying on only the judgment and making some pronouncements.
We'll get into
These
that.
people don't have the necessary experience.
Some of them are actually blaming you for not doing a good job.
Let me finish.
Yes.
These are observations of the judge, not observations of the total proceedings. And in any case, the matters that were cross-examined on that form part of the records may not have been picked by the judge. It doesn't mean we didn't cross-examine on those.
Okay, we'll get to that. I think you're referencing page 28 and 29 of this ruling.
Yes.
Well, I'll get into that. that. But why would Chairman Wontumi call you on the morning that, look, if I'm jailed, start appeal processes? You were not his lawyer at the time.
Yes, but appeal is a different process altogether. When the judgment is given, a client has the opportunity to change for the purpose of the appeal. So it doesn't follow that you do the case up to judgment and you continue as of right to be the lawyer for the appeal. No, he can change at any point in time. Probably at that time, he thought that if it happened that way, he would prefer that I probably be part. And indeed, from my discussions with him yesterday, he still wants me to be part of the appeal because
you have washed your hands off the case.
Oh, yeah, but you can always come back.
What did you see?
Because the appeal is a different process altogether
right.
from the instant case.
What did you see? The reason why you took the decision that in the dying days of the case, say, I don't want to have anything to do with you.
I gave my reasons at the time that because of the environment that we have created as prosecution and defense and even the court, it was not conducive for us to pursue justice under the circumstances. So sometimes personality clashes and things like that may bring situation in the courtroom even not conducive enough for us to be able to collectively seek justice. And indeed, don't forget that the object of the judge or the court itself is to seek justice. But if personality clashes are preventing all of us working together to seek justice, then it means that we need to recreate an environment that will give us that opportunity. And I thought that at that time, opting out to bring in a new person who would continue. And let me also put it on record, any new person coming had every opportunity, if you found the evidence inadequate, to recall witnesses. Indeed, he had even opportunity to recall even prosecution witnesses, and defense witnesses, and even call new or fresh witnesses. So the inadequacy of the evidence cannot fly because if you had opportunity to do that and you do, the presumption is that you found the prevailing evidence as adequate, which you rely on.
Atachi could have done that, and didn't do that.
Of course.
Okay.
Yes.
So they came in at a time where the expectation was that they must, the case was determined to a certain point, and dates for judgment was fixed. So they were boxing.
That is not the case.
Because they pleaded to do a few things and they were not granted the occasion to do it.
Anytime you come in and you are recognized, and don't forget, when the new lawyer came in, time was given to him to even observe. And
judgment date had already
been given.
Yes, but it was changed.
It was changed from
yes, because
even application. I'm coming. Even application for interpretation was quashed, and because
that is another matter.
Yeah, I'm just saying that there was no leg room for them to maneuver.
There was a room.
But let's get to the
given to him because at the point that he came in and announced himself in the case.
Okay.
The matters were all before him. And he said that I need to even study the brief, which was his legitimate right.
Yeah.
And it was all given. And having studied the brief, then you will come in with your prayers. I need to recall Mr. A or Mr. B or even call a fresh witness. At that point, if the application had gone that I need to recall Mr. A, it was something that the court would have determined and allowed for Mr. A to be recalled. And don't forget that Article 19(1) requires that he be given adequate time preparation to to be able to prosecute his defense. So he had every opportunity to recall or call any person to come to the box and give evidence.
I see.
Again, even if he wanted to even recall or call new fresh evidence, the application would have gone. There was no such application. Okay. If he needed any information beyond that which was provided to him, he could also have called for it. And again, I'm sure that he applied for record of proceedings, which normally it is a thing that you do at first instance, so that you have opportunity to
yes, how far the case has traveled.
And but you won't rely on the information I give you. You have to apply for official information from the court, the record of proceedings. So there was every opportunity to do anything if he found. But granted that that application didn't come, there's a presumption that he found the records to be adequate. So as for him, he must hold his peace. The person who has not had the opportunity...
Attach him must hold his peace. Yes. Hold on, I'll come to you, please.
Wait a minute.
No, I'll come to you. Yes,
so listen to me and follow. The person who would not have had the opportunity of reading the whole brief, particularly reading the record of proceedings and reading the address upon which the judgment would also consider, and comes out to say that you didn't do A, B, C, D, thinking that it is only the judge who has the preserve of lifting parts of the evidence in his or her judgment.
Okay.
Without listening to...
You are going into the details, but I wanted to find out from you, see, the narrative that has been put out about Chairman Wontumi's imprisonment is that he's a political prisoner. You handled most part of this particular trial. Do you agree with that?
I agree that the evidence on record cannot support the verdict.
Is he a political prisoner?
Well, I'm saying, I mean, I didn't see any politics in the records, but what I'm saying is that the judgment cannot be supported by the evidence. That one is, and that is in any case, that is how I will interpret the situation. But again, subject to three wise men who will also look at what we are all saying. But I'll be firm in my conviction that the evidence here in this records cannot support the conviction. If I have the opportunity, I will even tell you about the particulars of offense and even read the particulars of offense and see that it is even wrong. They said, for the first one, particulars of offense, you Wontumi, that you in the year 2024 in Samraboy, nothing happened between Wontumi and anybody in Samraboy. To start with, nothing happened between. Wontumi had not gone to Samraboy at any point in time, and there is nothing like that.
He hadn't gone to Samraboy. He had a concession in Samraboy.
Yes, he had. No, he didn't have concession to begin with. Did he have anything to give Wontumi as a person? And in the case of Wontumi and Akunta Mines, it was Akunta Mines that had the concession, not Wontumi.
Who owns Akunta Mines?
No. That's a different question.
No, that's the question.
No, that's a different question.
The trial judge lifted that corporate
a company, or I am a shareholder or my director of a company, doesn't make the company me. And therefore, if the company has something, it is not for me. So for you to even say that I gave something to Mr. B is fraud because I didn't have it. And the basic principle in law is that nemo dat code non habet. You can't give what you don't have.
Well, but the
so when you accuse him, no.
To lift that corporate veil,
we are doing
and pierce it
intellectual
and attack the owner.
No, that is in civil law. Please.
That's what
criminal liability is strict. It's strict liability. You understand? When you are my brother and you go to misbehave and they are charging you, you cannot say that because I am related to you. I am also equally guilty. You see, we'll come to all that in the appeal. But what I'm saying is that primarily, what we didn't have any concession to give. So if you charge him for having given the concession, if Akunta Mining had been charged alone, then the defense will be different. But Wontumi as a person, did he have it?
What arrangement did he have with Henry Oku?
No. Did he have it? The answer is yes or no. If he didn't have it, what did he give?
No, that's a question I'm asking you.
You see,
what did he give to Henry Okum?
And did he give anything in the records, in the evidence? He did not give anything because he didn't have anything to give. So I'm just saying that.
Okay. So who instructed Henry Okum to go on the land to do reclamation, or who gave that arrangement between the two of them?
If I don't have anything, can I instruct you to go and do something?
So then, how did Henry Okum land?
No.
No, I'm asking, how did Henry Okum appear on that concession?
So it is a concession in the name of Akunta Mining Limited. So it is only Akunta Mining Limited who can give. So granted that there is allegation that Wontumi may have engaged Henry Okum.
It's not an allegation.
No.
It's a fact.
No. Listen, if Henry Okum Wontumi engage Henry Okum, in what capacity would he engage Henry Okum?
I don't think. I'm ready to swing. Na I'm afraid. Oye minua kakrabajan. Ono ye MPC Sierra. Mezobu na yinzini na azaman de. Me no won komo. Me peda me besran. Na me ni di nkomo na amwon. Ti me kwa office. Ya bon komo ayedu baby na me ka chende. Azekote potin to o ma me ba manka. Nti o ma me kwan ma manka nchire. Me wi ana ya to nkomo na wa kan do. No see you what na me ka chire ne de. Asebe me nya mbo obiara ma de. Ono na me pede me zikan me bona ma de. Masam nyina anyi de. Se nyame ya adom na NDC fu obo ebuku no mu de. Ye be ko primary sir, ma ba contest na motu. Yeah. Nti na ayete.